This is Dr. J. Kent Gregory, and welcome to Chapter 3, Part 1 of Business Law and Ethics. In this chapter, we're going to talk about litigation. And so the first part of this discussion will begin with just an introduction to litigation and then attorneys and attorney-client privilege. So prosecution, this is the government side in a criminal case. A plaintiff is a party that starts a lawsuit in a civil case, and the defense is the party that responds to either a civil or criminal complaint. And then litigation, this is the lawsuit filed in court to determine liability and remedies. So these are just some basic terms to keep in mind. The parties involved. The litigation system relies on parties bring forth and defend their respective claims. So the litigants are the parties in the litigation, and occasionally a court may act sua sponte, which means on its own accord, and it's an action by a court without a motion from either of the two parties. And a motion is a request to a court for the court to take a specific action. So sua sponte means the court's going to act without a motion. The opposing parties, plaintiff, this is the party that begins the lawsuit in a civil case. So typically, these are people who are victims who have suffered some sort of legal wrong that the law recognizes. And then the defendant is the alleged wrongdoer against whom the plaintiff brings a suit. And these could be people, individuals, companies, and right now we're actually seeing the voting machine company, Dominion, um, brings suit against certain members of the Trump legal team. So, voting machine company versus Trump, legal team, and we can talk about that. So let me finish that up. Okay. So cases often involve multiple parties. So a counterclaim, this is a claim by a defendant against the plaintiff. So the plaintiff sues the defendant, and the defendant sues the plaintiff. The counterplaintiff then is the original defendant in a lawsuit, and then the counter defendant is the original plaintiff. And then joinder, this is joining of parties or claims in a litigation. So in essence, all of this could be combined into one court case. Attorneys. So parties hire attorneys to litigate most cases. However, there's the case where, which we refer to as pro se. This is where the litigant represents him or herself without an attorney. And it's Latin for on one's own behalf. And litigants can proceed pro se only if the judge allows it or if the court system allows that. And attorneys are sometimes called members of the bar. And the bar is a body of attorneys and judges. The jurisdictions of lawyers. So one thing to point out is the Juris Doctorate. This is the professional degree and doctorate in law, and it's required for practicing law in the United States. It's abbreviated as the JD. Typically it's a 3-year education, post undergrad education, and there's actually another degree beyond the Juris Doctorate, which is the LLM, but we won't talk about that today. But yes, so you go to law school, you graduate from law school, you've received your JD. So lawyers are only permitted to practice in jurisdictions where they're licensed, except for pro hoc vice, which is Latin for this occasion. This is a motion allowing out-of-state attorneys to practice in-state for a specific case or matter. And if it's granted, there's a fee that comes along with that. There are also things known as in-house counsel. So these are attorneys employed by and representing only one enterprise. And typically, in-house counsel is an employee of the company. So later on this term, we'll be able to have the chance to, or we will have the chance to speak with the members of the in-house counsel of Brown-Forman Corporation. And then outside counsel, these are law firm attorneys representing a company or other enterprise that are hired by the company or enterprise. The relationship between a client and an attorney. And remember, the client can be an individual, a series of individuals, or an organization or corporation. So rules of professional conduct. So rules for attorney conduct issued by licensing entities such as a state bar or a Supreme Court. And the American Bar Association, so the ABA, ABA issues a set of model rules for professional conduct for attorneys nationwide. Uh, Communications must be held confidential under the attorney-client privilege doctrine, and this requires all communications between client and attorney to be kept secret by the attorney from any disclosure to any person. Other privileges similar to the attorney-client privilege is spousal privilege, and this protects communications between spouses from disclosure in court. Doctor-patient privilege. This prevents medical personnel from testifying in court about their patients' communications with them. And then the kind of famously priest-penitent privilege. This protects communications between clergy and a penitent from disclosure. And most often we think of this as uh, in the Catholic Church, where someone goes into the priest to confess their sins, and the priest is not allowed to disclose that. So anyway, so there that brings us to an end of part one of chapter 3.